I only see the American number here. Thing. Okay. Okay, I see it.
Hello, wherever you are. Welcome to another edition of the Round Table. Today, promised to be another mind-blowing discussion, and we want to say welcome to our anchor there in Buchanan, Grand Bassa County, Ablige Radio, and the voice of Plebo all the way in Maryland. Maryland County, and the Liberty Radio in Monrovia. We also want to say welcome to Dr. Gompo, one of our panelists for today's discussion, and we will be concluding on. We will be concluding on our Article 61, which talk about immunity of the President of the Republic of Liberia. So we want to say welcome to the broadcast. We're just going to give you just 1 minute just to give your opening comments. We are looking forward to our next panelist, and hopefully he will be here soon. welcome to the broadcast. If you are just joining us, this is 45 City TV Roundtable, and the numbers to call to make your contributions, the numbers are right on the screen, and I want to say them. Voice of Plebo, 93.5 FM, 0776 697767. Ablige Radio 94.3 FM 08811667731 0775 734 774 and Liberty Radio 88.1 FM 077 0888 and our WhatsApp number is +1 952 201 9287. And those are the numbers you want to call to make your contribution to this program. I want to say welcome again. We want to start with our our anchor in Maryland and Grand Batter. Just 1 minute. Just tell us how you faring today, and then we want to proceed with our broadcast. Moses, are you there? Can you hear me? Moses is we got some cliches going on down there in Maryland. Okay, Moses, can you hear me?
Of course, I'm however, yeah, of
Okay,
course, I'm,
1 minute.
yeah, of course, I'm hearing you now. Yeah, so let me say thanks to the panelists who have joined us on the show, and let me also extend my warm greetings to him, as he joined us today, and I hope to, to always be with him, on the show. Maybe I'm also going to be learning new things from him as well. Thanks for the time.
Thank you. Ablige Radio. Ablige Radio, are you there? Okay, we will talk to Ablige later. We want to go strictly to our panelists. Dr. Gompu, you are welcome. You want to give your opening statement or 1 minute?
Yeah, thank you. I am happy to be here. The program is really useful for Liberia at this time. We are a nation that is building a democracy, so our citizens need to be informed about their rights under the Constitution. They need to also be informed about their responsibilities under the Constitution. And every Liberian is considered a citizen, irrespective of what position you are in. Whether you are president, you are a member of the House of Representatives, in the judiciary, or a student. We all have a common denominator as citizens of our country. And the Constitution provides rights and privileges for us, and also gives us different privileges and protection depending on responsibilities that we have as citizens. And one of those positions that are given some rights and privileges because of the position is the position of president. And Article 61 deals with that, with respect to the protection that the person who serves in that capacity as president has relative to lawsuits and other legal obligations. Notwithstanding that those privileges and those protections does not relieve the president of citizenship. So you still have your responsibility as citizen under the law, and at the same time, you have some privileges and protection due to the service you are giving to the country as president. And that is required for building our democracy. So our citizens need to learn about what the president's protections are and what are some of the limits to the protections that the Constitution provides. So I'm happy to be here today to help in that discussion. And I hope that the exchange or the discussion will be educational, where people can weigh in with their questions or weigh in with their comments with respect to their disagreements. My key background is that I am an economist. I'm a professor. I'm a public servant, and I've served in the Liberian cabinet as well. So I'm happy to be here.
Thank you so much. We also want to welcome Solomon. You want to just give your opening comment, just 1 minute? You are welcome on the broadcast. Solomon, are you there?
Are you hearing me?
Yeah, we can hear you now.
Thank you very much, Pastor Patience. Thank you to the 45 City TV. I am so elated to be here today to share my views on the Constitution. As we all know, the Constitution is the way in which serves as the model for the governance of our nation. And so I'm so happy to be here. Thank you for having me.
Thank you. Thank you for joining us. And then we want to go back. Thank you. Ablija, if you can hear us while we are moving forward, at the appropriate time, we're going to call you again. We want to go back to our discussion of the Constitution, which is the Article 61. And before we start discussion, let me just read the article. And it says, the president shall be immune from any suits, actions, proceedings, judicial or otherwise, and from arrest, detention, or other actions on account of any act done by him while president of Liberia, pursuant to any provision of this Constitution or any other laws of the Republic. The president shall not, however, be immune from persecution upon removal from office for the commission of any criminal act done while president. So this is the article that we are discussing. And the purpose of this discussion is educational. We want people to know the Constitution. We want people to know, some of the articles that are vague, that we think needs to be looked at, that needs reform. So join us and make your contribution. So, Honorable, something I like to call people honorable. The question, Dr. Gompo, this question is for you. Should the Constitution be amended to allow the president to be held accountable for actions taken while in office? And if so, what mechanism should be established to achieve this?
Well, the Constitution as is written now allows for the president to be prosecuted if the president commit high crimes and other treasonable acts against the republic. That is a responsibility, or that is an obligation, or that is a legal requirement that applies to all citizens. So the article now, I think it could be clarified, but as it is written now, to me, is implied that the president can be prosecuted for certain acts. The president say it's a 24-hour job. It never stops, because there's always a need for someone to be in charge of law enforcement, to be in charge of so many aspects of the country, to always be ready to be negotiating with other leaders around the world for the country. And that is why the Constitution provides some protections. because if you leave the president vulnerable by allowing anyone who has any kind of lawsuit, like, your house is on my land, or my land was taken by the president. If you allow the president to be subject to any lawsuits, okay, while he is president, I think you leave the presidency vulnerable, and that is not good for the country. So there has to be some protection there. And this doesn't only apply to the president, it also applies to members of the legislature. They have some protection. Members of the judiciary as well have some protections. Okay, so
right.
So I think that I think it could be clarified, but I don't have any major problem with that article of the Constitution.
Oh my God. All right. We will be also looking at that that article that gave the legislature immunity, but not today. But I want to post a question right at Justice. The question that was 1 minute. Okay, I think I should let Justice be the last. Let me go to Kwame here. Kwame, you want to respond to that question, and let me read the question again. Should a constitution, because we saw this sweeping immunity here in Article 61. Now the question here is, should the constitution be amended to allow for the president to be held accountable for actions taken while in office? And if so, what mechanism should be established to achieve this?
Okay, thank you very much. Again, I'm very sorry because of the gadget. It cannot allow me to access so that you can. I hope next time you'll be able to see my face. But again, comes to this question, Article 61. I think this article need to be amended. Why it is true that the framers of the law, in their own wisdom, thought it wise that the president should be prosecuted for any act done against the law. But again, I think we have a Pandora box here, where it is not clearly stated. Other people are arguing about this war removal, and again coming back to immunity. So I think it should be amended. The president should not be immune to acts committed against the law. Take, for example, if the president was engaged into act that has to do with rape, should we say the president should be immune from prosecution? I don't think that's what the framers' intent was. You understand me? So people will argue that, okay, only the Supreme Court can interpret this. They say, okay, our opinion would be different from the opinion of the Supreme Court. So I think there is something vague here. With this article, the provision need to be amended. But I don't think the framers' intent was to say that if the president or certain president order maybe the security forces to go burn the entire community, then you would say the president should be immune because he has just caused a genocide. So,
thank you.
Yeah, thank you very much.
Thank you. We want to go to Justice Janet. You want to respond to that same question?
You know, in the arena of the law, interpretation of law, whether it's statute or constitutional provision, statutory or constitutional provision, has rules. That's what we call the rules of construction. It's not enough to just read the language, the English language, and say this is the meaning. That's not how laws are interpreted. So one of the rules of construction is to look at the historical context and the intent of the framers when they wrote that provision. What did they intend to achieve? Firstly, the word immunity means that someone has actually committed crime but should not be held to account. That's what it means. That's what they call immunity. That though you have acted in violation of the law, but yet because of certain consideration, you are not held culpable. That's what they call immunity. Now, look at the time this constitution was put together. We had a military regime, and the military, in fact, wanted to stay on. When they started to entertain that desire, and knowing that returning the country to civilian rule would mean some constitutional order, they took a lot of interest in that process. So they set up the commission. The commission did its draft. They went around and set up another body to say, go and look at this. So what they could not do to influence the original commission, they did that with the one they call the advisory commission. I think they call it the advisory assembly. So they changed a lot of things. In fact, when Dr. Elwood Don addressed the Liberian people on one of these 26th day, he made a very profound statement. He said,
We're sorry for that interruption. That was Voice of Plebo, but continue, Justice. Before we go to our next question, just 1 more minute so you can conclude.
Yeah.
So you can.
So when Dr. Elwood Don made a very profound statement, he said the constitution, the draft constitution, was put together by professionals, people who were knowledgeable as to our political circumstances. But then he said, well, it was edited out by politicians. If you go to article, and nothing in the constitution says that more than article 97E. Article 97E, and I'm told, because I had the opportunity to meet with some of the people who actually participated in the writing of the constitution. I'm told that on that day, all of these people got in their, the PRC members, got in their military outfit and went to see members of the drafting commission and said to them, we brought this provision for you to put into your draft. And this is for our returning the country to civilian rule. What does that provision say? If you think Article 61 is too much, then listen to Article 97A. It says, no court or other tribunal shall entertain any action whatsoever instituted against the government of Liberia, whether before or after the coming into force of this constitution, or against any person or person who assisted in any manner whatsoever in bringing about the change of government of Liberia on the 12th day of April 1980, in respect of any act or commission relating to or consequent upon 1, the overthrow of the government in power in Liberia before the establishment of the government of the People's Redemption Council; 2, the suspension of the Constitution of Liberia of July 26; 3, the establishment, functioning, and other organs established by the People's Redemption Council; and 4, the imposition of any penalties, including the death penalty or the confiscation of any property by or under the authority of the People's Redemption Council, and it goes on. blanket immunity. So the point we're trying to make is that we may not agree with Article 61, but there's no other interpretation other than what it is. And the good thing is the organ in our constitutional democracy that has the authority to say this is what the law is, this is what the law means, is the Supreme Court of Liberia. The Supreme Court already interpreted Article 61.
Okay. Thank you,
but
Justice.
I think
Thank you.
that
Go ahead. You want to say something?
yes,
John?
I have some concerns. The last article that Justice Kabina just read, clearly that one was specific with respect to the PRC and those who participated in the coup. And even if anyone, and it's understandable, it is understandable, because they knew that they had taken so many lives and they were using the military power to protect themselves. So if you are asking them now to voluntarily give this country back to you for civilian rule, they're basically saying, let's have an understanding in the Constitution that we will be pardoned. All who participated in the coup, and everything we did during the coup to transition this nation from where it was to where it is going now, will be pardoned. You see? So you can clearly see that there's a specific a section there that just deals with that particular regime at that time. But this Article 61, where our focus is now, is supposed to be an article that applies as the Constitution continues to exist as we move forward. And when you read that article, it says that the actions of the president pursuant to the provisions in this Constitution. And so that clause provides an opportunity to explain that there are limits on the immunity that the president enjoys. And I think I have some disagreement with Justice Janet on his meaning of immunity. If I understood him correctly, he said immunity presumes that the person has already violated the law. And I don't think that I agree with that, because you could be immune as a protection while you are still innocent of having violated any law. So just because you are immune, or just because there's the law that provides immunity, does not mean or does not imply, in my view, that you are in violation of the law. I agree with him that it's the Supreme Court that is charged with the responsibility of interpreting the law. And I agree with him that in the past, the Supreme Court had reached a conclusion giving this blanket immunity to the presidency. But Supreme Court decisions are not permanent. Okay? If today we had a new set of justices.
No, that is not blanket.
When I say blanket, I mean that the interpretation was that the president has total immunity. Do you disagree with that?
No, I said it's not a blanket thing to say again. No, the Constitution says where the president acts in notorious violation of the law, the legislature must act But if they fail to act and he leaves or she leaves office, you can go after them. That's what the Constitution says. And it's the same like statute of limitation. There are certain things you could do, and the law says action will be taken against you during certain time period. When that time passes, you can prosecute that person for that time thereafter, as notorious as that criminal conduct may be. That's just the way the law operates.
But so you interpreting that as a statute of limitation? So if
Yeah,
for example,
they have statute of limitation for certain crimes. If the person is said to have committed a crime, because when you drawing on the indictment, you have to say when in your certain man that act was done, which constitutes a violation of the criminal code. You have to state that. If it is determined that time you stated, or to be the time the conduct took place, and it's outside, say it's 3 years, 5 years, whatever the time is, if it is outside that time, only on that basis it can be dismissed.
Yeah, but the statute of limitation, is relative to when it was discovered that you committed the act. So suppose you commit an act or crime against humanity. You commit a crime against humanity, like secret execution.
Let's now go.
Okay, let's go to our next question, because time is fast spent as well. Or should the immunity provision be limited to acts done in the president's official capacity, or should it extend to personal actions as well? So if we're talking about reform, this immunity, how will we, tailor it? Or how should we?
No. Frankly, this is one provision of the Constitution I will want removed, redrafted, and put in a way that people will be accountable for whatever they do. Because when you take the oath of office, one of the promises you make, or one of the undertakings, is that you will respect the laws of the republic.
Mm-hmm.
Yes.
Okay.
Yeah, I think that that is implied. That's how I look at it. If we want to revise it to make it much clearer, it can always be made much clearer, but it is implied that there are certain acts that the president would take. And some of those actions, for example, sending people to war. If the president sends people to war, sends the military to war, okay, if there was no immunity and somebody's child, is killed during the war, whether, through the military action or what have you, should the president be prosecuted for committing that, for the death of that child while the military is in action? You see? So then, right. So you have a situation there where...
Okay, Dr. Kompu, we'll come back to you, Justice, as well. Let's go to Kwame. Kwame, you want to respond to that question? Whether immunity, the provision should be limited to acts done in the president's official capacity, or should it be extended to personal actions as well?
Well, I think it should be extended to personal actions. And that is why I said in my opening, I said this provision within the Constitution need to be revised. It need to be amended in a way that it will give a clearer picture. Because any legal luminary may argue to say that, this is not being said like this is not being like this is not like that. Ogombu talking about it is implied. Partially within, Dr. Jana is also talking about issue that I may also be, I may also agree with what Justice Jana is saying. So I think to your question, yes, incapacity of his office and beyond be extended to personal action. Because in public policy, as a leader, and most of the as a chief executive, you take an oath to uphold to the rules of law. And by doing such, as a leader, you should lead the way. Because if you say in my personal thing, you go and do things that is what contrary. You go and do things that people see as what maleficent. People will say, but the president did it. Nothing come from Allah. Then I say I can do it. So always the president, always the leader should lead the way. Yes. So to your question, yes, not only to his oath but to his personal action.
Thank you, Kwame. I'll go back.
But then you're contradicting yourself, though. You're contradicting yourself because the question is whether immunity should be extended to personal action. And immunity means protection, right? Immunity means protection from legal action, right? Legal prosecution, whether it should be extended to personal action. And you say yes, right? If you say yes, then it means that you're asking for blanket immunity for both official and personal action, that there should be no legal consequences. Is that what you're saying?
I am saying in the absence of this law being revised, in the absence, because like Janet said, it is true. It is a Supreme Court that will interpret the law. And if the Supreme Court will say, look, this is our judgment, you will only talk because the Supreme Court is the final arbiter. So I am saying, yes, until this law be revised, that's why we're having this show, so that our constitution can be reformed. So that provisions that are not needed within the constitution, so that we can able to fix it. Because this provision is actually vague, it is. We agree that a president should not do things that will be contrary or be beneficial to the society. But again, this is the constitution. People will refer it to the law. Say the law does not say this. Even if the law says it, show us. Let's go to the Supreme Court. The Supreme Court will be the one that will interpret the law.
Okay, Dr. Gompo, would reforming Article 61 help to address the issues of corruption, abuse of power, or immunity in Liberia? Will it help if we were to reform this article?
Well, I mean, if the article is not being interpreted properly now, and people are using it as a cover for those in the presidency to commit corruption or to be corrupt and get away with it,
or they can just do anything and get away with it.
Yeah, I mean, if people are thinking that this provision is promoting corruption, and that clarifying it will help to reduce corruption, then there may be. But I think that when it comes to corruption in the nation, I think some of it has to do with the various organs of government not doing what they're supposed to do. Because when it comes to corruption, most of the time the president is not acting alone. The president does not go out and physically collects money or collect bribe.
Well, he is the head, so he has the greater responsibility because he gives the command.
Right, but listen, but know that the president is acting through government institutions. All those people in the cabinet and people in the judiciary who carry out things that the president wants that are against the law, okay, are the people really facilitating this corruption. So I am saying that if the Senate and the judiciary were doing their job effectively, the president, even with the existence of this article, the president would not be as corrupt as been in the past. You see, because
the president is protected by this article. So even whatever he does in the course of his duty, I mean, he can be held. So even if the people, working along with him, they are doing something else, or they choose not to do what he.
My interpretation is that this article does not protect the president to go out and be corrupt.
Okay.
If the court was independent and cases arrive before the court, they should be able to distinguish between areas where the president is protected and areas where the president is not protected, even with the existence of this article. And that's why you saw in the case of the recent Supreme Court decision in the United States, okay, when Donald Trump, people are saying that he has complete immunity. In the American Constitution, there is nothing in the American Constitution even regarding immunity. But yet the court were able to determine that in as much as the president takes an oath of office to protect this Constitution, and the Constitution provides for the protection of the citizens and of the state, there are acts that the president cannot do, okay, and be immune.
Thank you.
The court were able to do that.
Thank you, Doc. Let's go to Kwame. We're talking about reforming Article 61. Is it going to help the issues of corruption, abuse of power, or immunity in Liberia? And can you give us an example?
Bigly. I think by revising this provision within the Constitution, going to mitigate some of the broad day offense that the president commit most often in post-war Liberia. So this provision need to be revised. This immunity need to be spelled out so that the president can walk in chalk line. Like I said, the president is the leader, and the leader should lead the way. If the leader is involved into anything that is unlawful, trust me, all of which also share the stage and say, but the chief executive is also doing it. So if you want me to give you an example, take for example, issues that has to do with corruption, kickbacks, issue that has to do with criminal act as it relates to what Dr. Gomba is talking about. President gave a go ahead, go do this, and the security forces go there and do it. He should be held liable. Maybe for some misdemeanors, some minor offenses, maybe the president is supposed to follow the queue and maybe he did not do it. Maybe all other things that are minor, but anything that will have to be detriment to the survival of the state, then we need to erase that immunity. Thank you.
Before we go to Justice Janet, is there any relation to what we are discussing to that of what is currently happening in Liberia as it concerns the yellow machines?
Good. This is a perfect example. The perfect example. Maybe Justice Janet will elaborate much on that. And Dr. Gompu, I respect them. They are two great professors, and I'm so I'm very privileged to share the panel with them today. Yes, the yellow machine issue. I mean, how can you go and bring yellow machine without the acquiescence of the legislature? They didn't pass through the PDCC. You understand me? So this is abuse of power. These are things we are talking about.
If Dr. Kompu is saying that there's nothing wrong with that provision, it means the president is in it right.
No. I don't think that is what Dr. Kompu is saying. Maybe that Dr. Kompu, if you get it right, say it is implied. Meaning he said there's an offense that the president will commit that the Supreme Court will not come and say, oh, you should be immune to. And this one could be one of them. This is abuse of power. You abuse the law. You doing the oath of the president, he promised to uphold to the Constitution. And in the rule of law, in public policy, the legislature have to get consent, and then should pass through the PDCC, which of course they did not do it. So this is abuse of power.
Justice
Thank you.
Janet, you want to respond to that same question?
Sometimes it's good for us to make reference to our constitutional history just to understand the deeper meaning of the current provisions or the provision of the current constitution. The when Liberia was about declaring itself an independent republic, one of the things the Americans did was to send a professor of constitutional law to go to Liberia to help draft a constitution for Liberia. And that's the constitution called the 1847 Constitution. But we must remember that our constitution is very different in many respects from that of the American Constitution. One example is in the 1847 Constitution, the president could sit down at his office and decide to remove a judge, a justice of the Supreme Court, just by telling the legislature, sign for me a resolution. And they will sign a resolution and send it to him, and the person will be removed. You don't find those kind of things in American Constitution, but it was in our Constitution. So there are a lot of things that you find in the Liberian Constitution that you can't find in the American Constitution. So when you're talking about the legal culture now, you know that there was a time where the man who was in charge as agent or governor was at the same time the person who could write the laws for the republic. And he will also appoint magistrate, judges, and whatever came from there in terms of appeal, that person alone again will sit down and dispose of. We have all these kind of things. So the point I'm making is that the current constitution of Liberia has so many provisions that do not contribute in any significant way to issues of accountability. Lastly, I don't know how many of you follow up on the case with Brandon Samokai. The Brandon Samokai case was done. When he went to court, he said, look, I used the money because it was the president who gave me the authority to do so. Though it was clearly a case where this money had been used improperly, illegally. The Supreme Court disagreeing with it, said, well, if the president told you to do it and you knew that it was a crime, you should not have done it. And if you did it, you are personally responsible. But it didn't say whether the president authorized it or not. So let's assume that they established clearly that the president is the person who told him to do it. Could the president be held responsible? No, because unless you act as a legislature at the time you believe that the president has violated the law, if you let him sit there and nothing happens, the legislature doesn't act to remove him or when he leaves office. My understanding of what the provision means and by interpretation of the Supreme Court, the president will not be followed with any suit, because if he attempts to do so, the president has all the right to go to court, and the court is most likely than not to prohibit that.
Thank you, Justice. Thank you. We can take callers. Our numbers remain the same. Let me call the number again. We have the next 10 minutes to make our calls. Our number, sir, Plebo, voice of Plebo, 0776-697767. Ablige 088-1166-731, 0775-734-774. Liberty 0770777572, 0888-669-430, and +1 9522019287. So if you want to contribute, if you want to say something concerning the discussion, you can go ahead. Before we go to our closing comment, Doc, do you want to respond to?
Yeah, I think Justice Kabina is implying that the statute of limitation on the commission of crimes for the president ends with his departure from office. I don't know what I'm understanding him correctly. Is that what you said? Is that am I interpreting you correctly?
No,
Does the statute of limitation on the commission of crime of somebody who's in the presidency end with his departure from office?
No, the Supreme Court has interpreted Article 61 to the effect that if action is not taken to remove the president and thereafter prosecute him, you allow him to stay there until his tenure ends and he leaves office, that you can't go after him after he has left office.
Okay, so that means statute of limitation that
is not that is basically under the clause, immunity clause.
Okay, but I think I
only brought in the statute of limitation to say that is a general law that applies to any person.
Yeah. I think,
but it doesn't mean that the person will not have committed crime. The person may have committed crime, but all that person needs to do is to go to court and say, "What time did you say I committed this crime? What time?" You say, "Well, you committed the crime 2010." And then the statute of limitation says anyone who committed a crime of this kind, the person must be prosecuted within 5 years. And I agree with you, it's within 5 years from the time it becomes public knowledge.
Okay, right. You see, so from the time it becomes public
knowledge.
So if
the person, if the person, and there's something called reasonable determination.
Right.
Will the government or the prosecutor have known that this crime was committed? And if they put person on a they should have known or they knew, and they didn't act, and that time has elapsed, then the law will say, we're not even going to whether he committed or not. The fact that that time has elapsed, you can't hold the person culpable.
Right. So again,
I'm saying it's similar to the immunity clause. The immunity clause in under Article 61 simply say, if the president does anything, he will grab him now. And the way to grab him, elect men and women who have the courage to stand up for the law.
Okay.
If they do, the president leaves office, you can't go after him. That's what the Supreme Court said. You can't.
Well, no, I think again is their interpretation. We accept it because they are the Supreme Court. But I believe that if we had other independent justices, the decision might be different. And we Supreme Court, like you yourself.
Don't forget now, when that case came to court, it was the government of Liberia on an early justice that was trying to get to the former head of state.
Right. Yeah.
But the court disagreed with her.
Right. And no. who was it Louis Court? at the time? Was it Judge? Who was
It
the
was
justice? Louis Court, right? So again,
the chief justice was Johnny Lewis.
Right.
And I was on the court at the time.
Oh, you were on the court at that time.
And I agree with the majority opinion.
You agree with the majority opinion? Okay. So right. So the thing is,
right. In fact, I can confess here that I wrote the majority opinion for the court.
Okay.
So, and I rely on a lot of precedent cases in our jurisdiction.
Right. So
Chief Justice Johnny Louis did not agree with the majority. So he wrote both what he called dissent and concurrent. That's what he did. But the majority of the court agreed that this was the position as they understood it.
Yeah. So the thing is, again.
So it was an independent court. That's what I'm saying. Very independent court.
Right. Okay. So the thing there is this: that there is no way we can write the Constitution for it to be as clear as possible on everything that everybody will agree. If that is the case, if the Constitution was so clear on everything, then there would be no need to have interpreter. So the Constitution,
this one, my view have been, and not only there's a couple of them. I think we just need to go back. What is some kind of way to discuss, because we still got to work on this Constitution.
Of course. No, there are sections of the Constitution that clearly need revisions.
Exactly.
For me, the simplest one, as I said, was the term of office, because it's clear. We all agree, 5 is 5, 9 is 9. Okay, you can interpret.
Can you imagine? We all that happy, President, we are suggested that. And they put it to referendum, but because it was not followed through with any major education, the people rejected all.
Right. Yeah, and I can understand why, in fact, the court could have ruled against the Sirleaf government relative to the prosecution of Judy Bryant. Okay. Because, I mean, if you're going to prosecute somebody, you must be setting an example. Sometimes that can have implications for sometimes how some of these justices rule. Because if this, for example, you president, and they see under your leadership, the Auditor General is talking about your government is 3 times more corrupt. Then now you start going, you corrupt, your government is being referred to as corrupt, but then you now start bringing somebody else, previous president, to say, oh, let's prosecute this person. There could be people in the court who will say, no, we're not. If we go along with this, maybe that would just be an expansion of presidential power. So then they want to flip the president wing by saying, you're going to lose this case. They interpret the law the way it was, and whatsoever. So the law has a lot of room. And that's why you have these justices. You have these justices to come in with the interpretation. And when you change the justices, even some of the problems that
yeah, my name is Jerry. Want to call for me for the bullshit.
Okay, go ahead, make your input.
Yeah, thank you very much, and thank you, Honorable Captain Jana is still. The fact is that I want to know the word veto, because what I'm following now, the poor was veto, and we use veto power. I think it's a ball power. So I don't think the president will rule to even bring this machine, the poor that you must go through all these processes that you're talking about, go through legislation before this thing can happen. So I want to know from the owner that what does it mean? Thank you.
All right. Okay. The next person can also join us there. He just did the line 0776697767. We are closing, but again, you try calling and you seriously, but again, the line was a little bit dangling. But however, yeah, so I think it's up to Justice Jane concerning this this question, that the word veto, what does it imply when it comes to the authority of the president, that is the exclusive authority of the presidency?
Well, the veto comes in when, say, there is an action that needs presidential stamping, if you like. Say, for example, the legislature passes the budget, and the president has some disagreement on certain portion or all of the whole budget. The president is giving the authority on our constitution to say, I don't agree with this provision, the other provision, or I don't agree with the whole budget. The president can now issue that and say, I'm vetoing, which means I'm disagreeing and do not want this to become the law of the country or the passage of the budget. In that case, the president will veto and send it back to the legislature. But the law also gave the legislature the authority to disagree with the president and what they call override the president's decision. But that has to be done with 2/3 votes of the legislature, which generally is almost an impossibility in Liberia.
Okay.
But the president related.
Yeah. So I come in. I just want to do a follow up about this question that was just asked by one of our caller. The word veto, is it a literary term, or it's a term from the code? Because when you say veto, you are driving it from this angle, wherein that the president going to maybe disagree with the decisions of the legislature and say, I'm sending this back to the legislature. But the word veto, in my own mind or in my own understanding, is like trying to enforce a decision that was not reached, or that is likely to reach. Forcing a decision on the people. But when you say sending it back to the legislature, then I'm a little bit confused. Anyway, you know the law. But again, whether it's a literary term or maybe it's a code term, I just want to get a clarity on that.
Well, the word veto is a constitutional word. It's in the Constitution of Liberia. And there's a process.
Okay.
Yeah.
Yeah. So veto, again, like you said, veto just being, it's a way of saying the president can reject, right? The president can reject the law. The legislature passes a law and says this should be law. And the president said, no, this is not good for our country. I veto it. Meaning that the president is saying, no, it's not going to happen. Veto. That's another way of thinking about the word veto.
Thank you.
And when the president does that, then he got to send it back to the legislature.
Right, yes.
But the legislature also can reject what he says. But the only way the legislature can do that and become binding, become law, is if they can vote only by 2/3 majority.
Right. Yes.
And the way the presidency is so powerful, to get that number is almost an impossibility.
Yes. Right. So the Constitution is written in a way to us to make it hard to override. That's what I call it, override the veto.
Right.
Override the president's veto.
Okay, we're going to be taking our closing comments, and we want to start with Dr. Kompo.
Thank you for
1 minute, because with time fast spent already.
Okay,
go ahead,
so
Doc.
I'm looking at the time. Thank you very much for inviting me. I think it's been a very exciting show. I hope our listeners learn as much as we all learn together. And I think the whole process should continue. The Constitution indicated that the Liberian government is supposed to teach or to educate the citizens on the Constitution. And I think to build a strong democracy, at least the citizens should be informed about, the rights and privileges of each citizen and the limitation of those who have power under the law. So that way, when the court rules, they will not say that, oh, the court, has been biased, or the person has been, let's say the person has been found guilty because he's not of this tribe or he's of that tribe. You see? But if the citizens are not aware of the law and the way in which the law works, then they're more likely to refuse to abide by the law. So the more we teach the law, or the more we try to, at least at an elementary level, okay, not everybody will go to law school, but at an elementary level, let the citizen know, the limitation of the officials, especially the president and the people in the House of Representatives under the law.
Thank you, Doc. Justice Janet?
Well, I couldn't agree more with Dr. Bombo on that. In fact, those who drafted this constitution wanted it to be disseminated like what you are doing now. Under Article 10, it says the Republic shall ensure the publication and dissemination of this constitution throughout the Republic, and the teaching of its principles and provision in all institutions of learning in Liberia. That's what the Constitution says. So in other words, there are supposed to be provisions made in our budget to ensure that these kinds of programs are funded to let the people know the Constitution they have. Unfortunately, since the Constitution came to be in 1986, I can't recall any time where this provision was ever applied or complied with.
Thank you, Justice. Moses, 1 minute.
Yeah, so I will support, one of our panelists who talk about the Constitution should be taught in schools, and because what basically we are following in our schools nowadays, they are just social politics. They are not very, the Constitution of Liberia. Because if you have a counselor at law, if you have a lawyer who is teaching the student the Constitution, then of course they will have a clear picture about what the Constitution is all about. But when you have just a teacher from classroom who is doing all of the non-subject, bringing him to explain the service, I think he will just be explaining his own point of view. Thank you for the time so far.
Thank you. I want to say to our callers out there and our listeners, I want to say thank you for joining us. This program, we are looking at provisions in the Constitution of Liberia that needs reform. And the reason why we are looking at this is because we want to be addressing outdated provisions that are no longer applicable in our day and in our time. We want to promote also democratic values. We want to rectify, historical injustices, because if you look at the Constitution, a lot, we need to change within that Constitution. We want to be reflecting on the changes in society. We want to be reflecting on the values that we need to pay more attention to, improving governance, enhancing protection for individual rights, addressing political and social tension, modernizing institutional framework, and strengthening check and balances. And the reason goes on and on and on. So that's the reason why constitutional reform is very important. And it is time that you look at your constitution. Don't just be voting for people because you want to vote, or because they gave you bag of rice, or because they gave you t-shirt, or because you are related to that person. Your future depends on it, and the future of your children depends on it. So we want to say thank you for joining us. I want to say thank you to our panelists, Dr. George Gompo, and I want to say thank you to Justice Cabinet Janet for joining us, and also our anchor in Radio Land, Voice of Plebo, Ablige, and Liberty Radio. Thank you so much, and we will be here on the Roundtable 45 City Roundtable next Thursday, and I'm your host, Pastor Patience. See you again, and don't forget, join us, make it a date with the 45 City.